Hello, my name is Salsa Alfi Widowati. In here, I will explain about Islamic Family Law in Singapore. The existence of Islamic law in Singapore cannot be separated from the Islamic community in the country. Due to the need for formal Islamic law, Muslims in Singapore are working hard to get the government of Singapore to pass a law regulating Islamic personal and family law. These efforts were pursued through representatives, but individually and through Muslim organizations, were worked for many years, and it was not until 1966 that the government issued a draft Act of Parliament and accepted the Administration of Muslim Law Act 1966, abbreviated as EMLA. Administration of Islamic Law (EMLA) Act is an Islamic law legislation, however, this administration is not Islamic law itself. This that provides a flexible space for the Islamic Religious Council, religious courts, and Islamic marriage register in applying Sharia law. A consequence of the existence of EMLA was the formation of the Islamic Religious Council of Singapore. This legal commission serves to issue fatwas related to Islamic law, and under Article 32 of EMLA, this religious court is empowered to hear and decide issues that occur among Muslims or marriage based on Islamic law, which includes one marriage, two divorce, or which includes talak, divorce talak, fasak, and huluk. 3. Judgment. 4. Division of joint property when divorced. 5. Payment of dowry, maintenance, and on. Next, the Administration of Muslim Law Act 1966 (EMLA) and the Women's Charter as for the terms of marriage in Singapore as follows. 1. The labor law in Singapore is contained in Article 93 of the Administration of Islamic Law Act 1966 or EMLA, which states that every Qadi and Naib Qadi shall keep such books and registers as are prescribed. 2. Provisions on the age of marriage stipulated in Article 96 of the EMLA of 1996, which explain that people who want to get married must be 18 years old for both men and women. 3. Singapore regulates officially the sanction received by the parties cancelling their engagement, as stated in Article 94, Paragraph 1 EMLA 1966. 4. What is entitled to be a wali nikah in Singapore is wali nazab. A woman does not have a wali nazab or wali nazab does not wish to be a wali without a reason justified by Islamic law. Then the right to replace her is qadi. 5. The maintenance of the husband who has been regulated in Article 51, Paragraph 1 and 2 AMLA. 6. For a husband who wants to marry more than one woman or polygamy must make a special request by including the reasons for the desire to polygamy to Qadi. 7. Marital property in Singapore consists of two, namely joint property or property acquired during marriage, and communal property or property acquired before marriage. However, in Singapore, both property and joint property can be made into marital property in the event of divorce. 8. The window marriage is regulated in Article 97, paragraphs 1 and 2. Divorce in Singapore is settled in courts Syariah of Singapore in 1955 as a manifestation of the result of an institution formed by the government. The court adopted the EMLA regulation of 1966 as its legal basis. There are several types of divorce prescribed in Singapore as contained in the EMLA of 1966 is talak, divorce taklik, fasak and huluk. The EMLA also requires the Qadi to only record divorces that are based on the consent of both parties. If one of them expresses disagreement, then the matter is left to the heads of religious courts to decide. There are four important issues to be addressed regarding the recording of divorce: payment of orja, mut'ah or gifts as a result of divorce, child maintenance or hadhana, division of joint property after divorce,